Hi. According to the company's law, directors and officers have two basic duties towards the company: the duty of trust and the duty of care. In the next few minutes, we will examine what does the duty of care include and what is the director's liability in case he or she breached this duty. Directors and officers' duty of care towards the company is set under the company's law. According to the law, as part of the duty of care, a director or officer is expected to obtain information before making a decision and to act in an informed manner. The company's law requires a director to adopt reasonable means to obtain information on the profitability of an act brought to him for his decision or of an act performed by him. According to court rulings, a director's duty is not absolute. He is required to adopt reasonable means to avoid damage. However, he is not required to guarantee that indeed no damage will occur. In the Mariv decision, the judge noted that the duty of care does not mean that a director should avoid from taking risks. Far from that. The main purpose of the company is to manage business, and taking risks is an inevitable part of making business. The meaning of the duty of care of an officer is that the officer shall make for the company decisions which constitute educated risk-taking. As can be seen, the mere fact that a decision made by the directors led to financial loss will not necessarily lead to imposing personal liability on the directors. If a business decision made by directors has gone wrong, the directors have several levels of protections which protect them from liability. The basic level of protection of directors is the protection provided to them under the business judgment rule. The business judgment rule was adopted by the Israeli district courts in several cases. However, the exact extent of the rule and its applicability have not yet been tested by the Supreme Court. Theoretically, according to district court's decision, an act or decision of a director will enjoy the business judgment rule protection if it fulfills the following terms. First, the decision was made without conflict of interest. Second, the decision was made in good faith. And third, the decision was made in an informed manner. A decision which fulfills all three terms is presumed to be proper, and the court will not interfere in its content. According to the business judgment rule, when examining a business decision, the court will examine the decision-making process, however, will not examine the content of the decision, even in cases where the decision seems to be unreasonable. It should be noted that although the Israeli courts adopted the business judgment rule, in practice they are very careful before releasing directors from liability based on this protection. One of the main obstacles of directors who wish to enjoy the business judgment rule protection is proving that the decision was made in an informed manner. According to court rulings, in order to determine whether a decision was made in an informed manner, the court will first examine the content of the minutes of the board of directors meeting. This is the best evidence which can be presented to prove what the decision-making process looked like and whether it was proper. If the court reaches the conclusion that a decision was made in an uninformed manner, it will not be protected by the business judgment rule. However, this will not necessarily lead to imposing liability on the directors. In such case, the court will examine the content of the director's decision, while the burden of proof that the decision was reasonable will lie upon the directors. The Israeli law allows a company to provide its directors and officers an additional level of protection, an exemption. The possibility of a company to exempt its directors from bearing liability towards it was set under the company's law. According to the law, a company is entitled to exempt a director or officer from liability arising from his or her breach of duty of care towards the company. In the case of Ashash versus Atiyah, Judge Ruth Ronen ruled that the protection provided to the directors by the exemption is wider than the protection provided under the business judgment rule. According to Judge Ronen, the exemption permitted under the company's law includes exemption from liability to decisions which were made in an uninformed manner, as long as they were made without conflict of interests. Therefore, decisions which are not protected under the business judgment rule may be protected under an exemption. However, According to the company's law, the protection of a director or officer under an exemption is limited. The law prohibits a company from exempting a director from liability under several circumstances. For example, a company may not exempt its director from liability arising from an act made with a purpose to gain a personal benefit. For the purpose of our discussion, we will focus on another limitation set under the law to the company's ability to exempt its director from liability. According to the company's law, a company may not exempt its director from liability arising from their reckless or intentional breach of their duty of care. This limitation was tested in an interesting decision handed down in the case of Ma'ariv. Ma'ariv was a printed newspaper which suffered losses during several years. In March 2011, the board of directors of Discount Investment approved the purchase of control of Ma'ariv in consideration of 120 million shekels. The minutes of the board meeting approving the transaction was very short and reflected no real discussion regarding the transaction. As a result of its investment in Ma'ariv, Discount Investment suffered significant losses. One of its minority shareholders filed a motion to approve a derivative action based on the board members' breach of their duty of care towards the company. At the time the decision to purchase Ma'ariv was made, the directors had a valid exemption from the company. Therefore, the directors argued that even if they indeed breached their duty of care, they are exempted from liability and thus cannot be held liable. Despite the exemption, the district court decided to accept the motion and to allow the plaintiff to bring a derivative action on behalf of the company against its directors. In its decision, the district court ruled that the facts presented in the proceedings are sufficient to support a prima facie finding that the directors acted recklessly and thus may not be entitled to enjoy the exemption provided to them. The court stated that a director will be considered as acting recklessly if proven that he was indifferent to the fact that his acts constitute a breach of his duty of care. Such mens rea can be expressed in two ways. Procedurally, if a director shows no interest in the information which should serve as a basis for his decision, and materially, if a director makes a decision based on irrelevant considerations instead of considering the company's benefit. In the Ma'ariv case, the court ruled that there was no real discussion by the board prior to the decision to purchase Ma'ariv, and therefore, from the procedural aspect, the directors acted recklessly. In addition, the court found that plaintiff established a sufficient basis to put a prima facie finding. The approval of the transaction by the board was made for irrelevant reasons, to please the controlling shareholder who wanted to control a newspaper. The Ma'ariv decision is the first court ruling which determined that specific acts made by directors should be considered recklessness, and there is currently no Supreme Court ruling on this issue. The only Supreme Court rulings which analyze the term recklessness refer to criminal meaning of this term, and therefore there's a legal uncertainty as to what conduct can be considered as reckless. To summarize, while directors and officers are granted several levels of protection for breach of their duty of care, the protections provided to them are not absolute. According to court rulings, directors are allowed to make mistakes. However, they must show that they care. A director who was indifferent to the results of his decision can find himself exposed without any protection. Thank you for listening.